really is a pleasure to be here. I've been working with many of the Chinen&Arinaga advisors for most of the years that I've been practicing law. And I've been practicing law for 35 years, so it's been a long time. Now, what am I going to talk about today? I'm going to talk about owning a piece of paradise, the benefits and the challenges of Hawaii real property ownership. So how many of you own real estate in Hawaii? Yay! I'm guessing that's why many of you are here today. And really, when you own real estate in Hawaii, you're very fortunate. Hawaii is a beautiful place, the weather's great, the air is clean. That's why many people call it paradise. But there are some special challenges with owning real estate in Hawaii. So my hope is, after today's presentation, you'll be able to better navigate those challenges and really enjoy the benefits of owning a piece of paradise. So, the way that I've set up this presentation is in 8 separate parts. And we happen to have 8 Hawaiian islands, so I've associated each topic with one of the Hawaiian islands. Our first topic is the island of Oahu, and we are going to talk about forms of ownership, because that's what it all starts with. If you're getting a piece of property, the realtor is going to say, how do you want to own the property? Well, the first one is a tenant in severalty. What does that mean? That means if you own it individually, there's only one owner, and that person who owns it has complete control. But by the same token, if that person becomes incapacitated or passes away, it could become difficult. And that's why many times, rather than owning the property in the person's individual name, they will own it in a revocable trust. And we'll talk about that in a moment. Other times, they might own it in an entity, like a limited liability company. And the choice of entities could be, let me tell you, a presentation in and of itself. But that's the first form of ownership. Second form of ownership is tenancy in common. Tenancy in common is a form of ownership where there are multiple owners. And the owners can own different percentages, and each owner can hold it in a different way. By that I mean, maybe one person owns it individually, another owner owns it in a trust, or another owner owns their proportionate share in an LLC. Tenants in common is very flexible. It is probably the most common form of ownership amongst siblings. So how do siblings get the property? Mom and dad passed away. Mom and dad leaves it equally to 3 siblings. In general, the ownership is tenants in common. Now the challenges. So even though it's very flexible, when you have different people owning the property, what happens if one person dies? There might need to be a probate over that person's estate. It does not automatically pass to the other owners. Tenants in common stays with the person who, each of the owners. So each owner, as I mentioned earlier, might want to do a trust or do some other form of ownership so that if they become incapacitated or pass away, it can be administered. The other thing is, how do the multiple owners manage the property? Many siblings, they get along great and they are able to do it all together, but other times it can get a little more complicated, especially after, say, the siblings pass away and later on it's cousins owning property. So many times for tenants in common ownership, we help people create what's called co-tenancy agreements. So it sets forth the responsibilities and the benefits that each of the different owners have. The third form of ownership is joint tenancy with rights of survivorship. Now that one, everybody has to be an individual and everybody has an equal ownership And when the person passes away, it goes to the survivors. So why I'm focusing on these two is that you can see by virtue of how you own the property, there could be a significant difference. And so when you're acquiring this piece of paradise and you're being asked, under what form are you going to own it? That's a really big decision. So joint tenancy, some people love it because they say, oh, it's so simple. Something happens to me, it goes to the other person. Other people don't like it because if, say again, we had siblings, one of them dies and he was thinking it was going to go to his kids, and instead it goes to his sister. So that decision can have a significant impact. Okay, the final form of ownership is only available for married couples, and that's called tenancy by the entirety. And so for those of you who are married, because I see a lot of couples, I'm assuming if you might own your property in that fashion. And just like joint tenancy with right of survivorship, if one person dies, it all goes to a survivor. So it makes it easy. It also has another benefit. Because it is considered owned by the marriage, a creditor of only one spouse cannot get at tenants by the entirety property. That's why if any of you ever try to get a loan and you're married, you'll notice that the bank is saying, hey, I need the signature of your spouse. Because the banks all know, hey, if you default on this loan, they're not going to be able to collect against your home if it's owned tenants by the entirety, unless your spouse was also responsible for the payment of that loan. So tenants by the entirety property, it can be wonderful. But by the same token, remember there's always benefits and challenges. It cannot be changed unilaterally. So the couple has to work together. Tenancy by the entirety can only be broken by death, divorce, or mutual consent. I'm hoping a fair amount of you might have already done your estate plan. If you did it prior to 2012 and you transferred the ownership of your property into your trust, you would not have tenancy by the entirety protection because the law said if you put it into trust, the trusts are not married to each other, so no more TE. But in 2012, Hawaii passed a law that says if it was in tenants by the entirety and you put it into, say, the husband's trust half, the wife's trust half, or a joint trust for husband and wife, you can continue to have the tenancy by the entirety creditor protection. But the deed must contain certain special language. So I just mentioned that as a point of reference. You know, we often, when I do talks on estate planning, we talk about, looking at updates and things like that. And that could be a situation that might apply for some of you who had done your plans over 10 years ago. Okay, now, once the form of ownership has been established, the document has to be recorded. And you might be thinking, okay, this is now so technical, but there is a reason why I want to go over this from a practical perspective. Okay, I've associated system of recording with Kaho'olawe because Kaho'olawe had really two purposes. It was a training ground for many years, no longer used in that way. Now it's used for Native Hawaiian cultural purposes. So like Kaho'olawe that had two purposes, in Hawaii we have two systems of recording. The first system is the regular system. Regular system is very simple. You can actually record anything there. And that's why sometimes if you ever had a title report and it might say there was a deed recorded where somebody else said they owned your property, Okay, regular system, you can record it. Does it mean that that person owns the property? No, but it's so flexible. If you watch the news and you hear about, sometimes people are recording all kinds of things. That's how it happens. But we also have the land court system. The land court system is a very strict system. It requires a lot to record things. But here's where I wanted to bring up a real practical pointer. If your property is land court, you need to make sure that the legal description is really up to date. Because if you want to do anything with your property, say you want to get a mortgage or you want to sell it, and something is not right, a land court petition has to be filed. And since the pandemic, unfortunately, the processing time has been very long. And so I've had situations where if you got to change the marital status, when you purchase the property, in the deed, they always ask, are you married? What's the name of your spouse? What if the spouse died in the interim? By right, there has to be a petition to note death or other things that becomes important. You change your name. I have a client who's changing her name. We have to file land court petitions. And unfortunately, because of the time frame, it can cause a problem with whatever transaction you're seeking to close. Now, your question might be, how do I know whether my property is land court or regular system? And if you were looking at two houses right next to each other, you cannot tell. You can only tell by looking at the legal description of the property, which is on the deed. So, and a very simple way is if you look at your deed and there's two recording blocks. It says regular system, land court. Which is the side that has the stamp? If it's on the regular system, land court, sometimes, believe it or not, there'll be dual system. Especially if you own like condos and whatnot, because condos could have been built on multiple properties. And one property might be land court, one might be regular system. Every year almost, there is a bill with the legislature, Hawaii legislature, where they're talking about getting rid of land court because it is so strict. But as of right now, it's in effect. So that's just a practical pointer.